Just another installation of our series of personal injury pointers. I've been a personal injury attorney with Peterson Burke and Cross since 2005. We have offices in Green Bay and Appleton, and we help people who've been injured in accidents or falls. Just a quick disclaimer that in doing this video, I'm not creating an attorney-client relationship. If anyone has questions, it's really best for you to call me and ask for my advice. These are general topics. They may not apply exactly to the facts that you or your loved one may be dealing with, but we do always offer free consultations, and I'm happy to talk to you and see about your specific situation and if there's anything we can do to help you out. As always, don't hesitate to call. Our number here is area code 920-831-0300, and you can also find us on our website, www.foxriverlawyers.com. So today I'm talking about somewhat of something that I think is kind of a fun thing to share with people who aren't necessarily in the legal profession. I'm talking about 3 things I'm not allowed to tell a jury. What I think people don't understand in general until you have this experience or work in this field is there is a lot of information that I'm just straight up not allowed to tell a jury in a jury trial. Before we get to that, let's talk a little bit about why does a jury trial happen. So again, the work I do is personal injury. I represent plaintiffs, the people who are hurt. In a civil case, if you can't work the case out through negotiation, then the end result is you try your case, you put on a trial to a jury. And a jury makes decisions about who is at fault for, in a car accident, for example, and what injuries were sustained in that car accident, and what amount of compensation is fair for what a person has gone through. As a general comment on what's called the tort system, this method we have, I don't like it that our only method is to provide people compensation money for what they've been through. There isn't a better system that I can come up with. People have gone through horrific things, sometimes having lifelong injuries, whether that's scars or loss of a limb, and even more terrible things where people pass away and their loved ones don't have someone in their family anymore. There isn't a way yet for us to bring people back or to fix all their illnesses. At a time when medicine advances to the point that all injuries can be cured, I will gladly do something else. I would like nothing more than for my job to no longer exist because everything is safe and nobody gets hurt. But that's not the world we live in right now. So what this society has determined is that the way to help people who've been injured through no fault of their own is to provide them monetary compensation, money. And I really like to look at that as the money people receive from a personal injury case is supposed to help them out in some other avenue. If someone suffered an injury where they can't return to their current job, the compensation is supposed to provide that backup income to do something to help make the life easier. When there's times where people have been through a really stressful situation, perhaps the compensation can lead to, a down payment on a home or something else to generally compensate and kind of balance that scale on you had this really bad thing happen to you that wasn't your fault, and now here's a way to correct it to make something else in your life a little easier. So getting back to my overall point, juries determine the value of a claim if it goes to that point. And in talking to juries, there's a really complicated set of rules of things I'm not allowed to tell them. They're called the rules of evidence. There's a whole chapter in the Wisconsin state statutes that goes through it. And a lot of people refer to this as a sieve, I prefer the term colander, but you drain your pasta, the water comes out, the pasta's left. That's the same as all the evidence in a case or what goes to trial is. There's some pieces of information that are going to be allowed to be told to the jury, and that's your pasta left in your colander, and the water that comes out is everything else. As a general concept, relevant evidence is admissible, irrelevant evidence is inadmissible. Those are key terms, of course, and there's tens, if not hundreds of thousands of appellate cases that discuss what is relevant evidence, what isn't. We're not going to really go into the fine details of those, just to kind of explain some of those points. Again, a lot of the work I do is people who are hurt in car accidents. If the driver in a crash doesn't have a license, it's unlikely that's relevant evidence. A lot of people can lose their license through failure to pay fees, may never have one. The lack of a license doesn't necessarily mean someone is more or less likely to drive dangerously or be negligent. And that goes for both sides. I've represented people who've been hurt. You know, if my client was sitting stopped at a stop sign and that person didn't have a valid driver's license and was rear-ended, those injuries are no less valid or real because they failed to have a license. Another simple example in a car crash case, the fact that a driver in the crash is not a U.S. citizen, that's not likely to be relevant nor admissible. Again, if my client is not a legal resident or a U.S. citizen, the fact that my person sitting at a stop sign is rear-ended, has injuries, whatever's going on with their immigration story has nothing to do with those injuries. And the same is true usually for the defendant driver. So those are just two quick examples of relatively simple things that are not likely to be admissible. But clients, and I think the general public feel like some of these small pieces can lead to whether or not a person is an overall dangerous person, or an overall risky person, an overall bad person. And those sort of commentary, points are not likely to be ever admissible in court. But I want to set those things aside for kind of three general areas where I'm not allowed to tell a jury that really they should know. So for all of you who may someday be a potential juror or have your case go to a jury, I want to make you aware of these three things. The first thing I'm not allowed to tell a jury is that in a personal injury case, 99.9% of the time, we're pursuing a compensation from an insurance company. It is extremely rare that an individual person, even if that person was at fault for causing an accident or a crash, it's extremely rare that an individual person will ever be paying money. The vast majority of cases are pursued against insurance companies. There is all kinds of law that says I'm not allowed to tell that to a jury. I'm not allowed to say, hey, don't worry about Mrs. Johnson who caused this crash. Nobody's going after her home. We are pursuing damages from insurance. Insurance is a good thing for society. It costs money, but it protects us so that we are looking at a risk-sharing pool. There's jury instructions. There's a standard jury instruction in Wisconsin that states, even if you've heard mention of insurance, you're not allowed to consider that in determining what is it worth for the injured person to go through what they've been through. And it's something I understand to some degree. I don't think the fact there is insurance should make a case more or less valuable. But at the same time, I would really like jurors to understand that this is a claim against an insurance company. My injured plaintiff is not trying to take someone's home, is not going to be taking the livelihood of another human being. This is about collecting from insurance, which we all bought and paid for a reason. That's one major area where I'm not allowed to tell a jury something that I really think would be useful for jurors to know. This is all about insurance. This is not about collecting money from individuals in the vast majority of personal injury cases. The second big area that I'm not allowed to tell a jury about that I think they really should know about is the doctrine or the legal concept of comparative or contributory negligence. The end result of any civil case typically is a sheet of paper. The one I use most often is called a special verdict, where a jury has to fill out a form at the end of the jury trial. And that jury trial concludes by asking the jury who is at fault for the accident. They may ask, and again, car accidents are just easier to describe, but there's unique facts for every circumstance. Was driver A at fault for the crash? Was driver B at fault for the crash? In doing that, if the jury would determine both individuals are at fault for the crash, they're then asked to put in percentages. If you believe driver A was at fault and driver B was also at fault, determine which percentage of fault each one has. Let's reframe this to say, do you believe the plaintiff, the person who's injured, was at fault for the crash? And do you believe the defendant was at fault for the crash? If the jury determines both the plaintiff and defendant are at fault, then the jury has to divide up the pie of 100%. You may have heard, and I have heard this from clients, you may have heard things such as, simply for being there, you're 10% at fault. This is 100% not true. There is absolutely no law in the state of Wisconsin that holds that. The jury is allowed to allocate fault however they believe the evidence supported it. If the jury determines that the plaintiff was stopped at a red light when rear-ended and therefore has zero fault, there's no law or no rule or no anything that says they have to say, well, you were there, so you have some share of the blame. This is an example of propaganda that insurance companies have put out to try to lessen their impact, and I'll explain why. So after the jury determines that if there is a split percentage, and they put down their numbers, the next step the jury is asked, without considering this former part about who's at fault, what sum of money do you believe fairly compensates the plaintiff for everything the plaintiff has been through? And they may be asked about past medical bills, future medical bills, past wage loss, future wage loss, past and future pain and suffering, disfigurement if there's any scarring or permanent injury. The jury is told to figure out those numbers without thinking about that split on who's at fault. Now, what I don't get to tell the jury is that any fault assigned to the plaintiff reduces that recovery. It reduces that award by a pro rata distribution. So to use very simple math, if a jury determines that everything my client has been through is worth $100,000, and the jury believed this myth that, well, you're 10% at fault just for being there, even though my plaintiff was stopped at a red light and rear-ended. I don't know what else they could do. Then that 10% reduces the plaintiff's recovery. So rather than receiving the $100,000 of jury awards, the plaintiff only receives $90,000. This doctrine is more complex than this. There's more factors that can play in, and different hypotheticals and different analysis, which is why I said if it's your specific facts, please call me and let's talk about it and let's go through it. Again, we offer free consultation. But I'm not allowed to tell a jury that if you say, well, we determined the plaintiff is 60% at fault and the defendant is 40% at fault, but we still gave the plaintiff $200,000. No, you didn't. Once the plaintiff is more at fault than the defendant, so if there's just two parties in a case and the plaintiff is 51% at fault and the defendant is 49% at fault, the plaintiff loses and receives nothing. It's confusing to jurors that they don't know this comparative negligence analysis takes place. And I've seen verdicts where juries have done their own comparative negligence in the damage award. So let's say, for example, a jury believes that the plaintiff is half at fault and the defendant is half at fault. And they do that with their percentages. They go 50-50. Let's say again, and I just like numbers for easy math, that the plaintiff's past medical bills are $100,000. Well, the jury says, well, we think the plaintiff's half at fault, so we're only going to award $50,000 for past medical bills. Once that happens, the comparative negligence distribution still works out. The plaintiff doesn't collect $50,000 at that point. The plaintiff collects $25,000 based upon the negligence assigned above. There's been legislation through the years proposed, typically called the Sunshine Act or Sunshine Law, to allow people to explain this to juries. When juries are given a case, there's a whole set of jury instructions where the law is defined for the jurors to understand. This concept is one I'm not allowed to tell them about, and the attempts legislatively to change this have been unsuccessful for decades. It's just not something we're allowed to share. But I think it's important for potential jurors and potential clients to understand this, that there are times that the message that the jury wants to send, what the jury thinks is fair, is not going to be accurately depicted due to contributory or comparative negligence. The third thing I want to talk about that I'm not allowed to tell juries is actually a two-part. There's certain closing arguments that have been deemed so effective by the plaintiff, the person who's hurt, that we're just not allowed to have them anymore. The first of these is the golden rule. I am prohibited from telling a jury, what do you think it would be worth to go through what my client, the plaintiff, has been through in this case? We're just not allowed to say that. It's so compelling to think, well, what if I put myself in that person's shoes? What if it's a mother who lost a child in a car accident? I'm not allowed to tell the jury, what would you think it would be worth if this happened to you, if you lost your loved one, if you lost your child, if you lost your spouse? I'm just not allowed to talk about it. That's called the golden rule argument. We're just not allowed to use that argument, and doing so would result most likely in a mistrial and having to redo the case entirely. I find it baffling that the legislature, the courts, whatever is the ruling body on this issue in this state or others, has determined that no, it's just too effective. You can't use it. We all should be thinking that. Anytime we're reviewing a case, whether it's as a jury or an attorney or an insurance adjuster, anyone involved in this process, we should all be thinking of other people and what that other person has been through and how it would feel to me or to you to go through those things. But it's just an argument I'm not allowed to make. The second argument and closing arguments that I'm not allowed to make is called a per diem, or that's Latin for by the day, a per diem argument. What a per diem argument is it looks at what a plaintiff has been through. So let's say I represent a plaintiff a woman who had a scar on her face. And if that woman was me, and I had a scar on my face that was upsetting to me and bothered me and reminded me of the accident. Every time I looked in the mirror, I felt that people stared at my scar. It impacted my ability to do videos like this or to speak publicly in my profession. I may say that I think this is worth $10 a day for the rest of my life because this is never going to go away. That would be an example of a per diem argument. The remaining life expectancy for me is 42 years. I'm almost exactly at midpoint of my life expectancy. I don't know if that's good news or bad news. Made it halfway. So if we look at that in days, I supposedly have, by government statistics, 15,585 and a half days left. So if I were to ask for a per diem argument of $10 a day, that would lead to $155,585.50. That amount may not be too shocking depending on what the scar is. But let's say we change that to my per diem argument of you should award $100 a day. The jury should compensate, should reimburse the plaintiff $100 a day for what the plaintiff has been through and will be through for the rest of my life because of this scar. The difference of $10 to $100 may not be shocking, but once you start to put it in this daily concept, now those 15,585 days I have left lead to compensating the plaintiff with $1,558,550. And the courts have determined that, again, this is just too powerful. I don't see any reason why people should think about this. If there is a case where there is an injury that's not going to change, it's not going to go away, it's always going to be there, there should be some thought of how many days are left. Now, we don't know the future. We don't know if I tip over tomorrow and get hit by a bus or have a heart attack and I'm done. But we also don't know if I would actually live 60 more years. You don't know. But it's interesting to me that for plaintiffs, there are these two closing arguments that are just prohibited in general because they've been found to be too successful. It feels that there's a thumb on the scale against people who've been hurt. And I think that's wrong. So that's why I think it's useful to educate people. Just to recap, the three things generally I'm not allowed to tell a jury. I'm not allowed to tell a jury that this is all about insurance money. We're not trying to reimburse the plaintiff for what he or she has been through with the personal assets of the other driver generally. That's not a successful claim in most cases. We know that nobody was trying to cause this. It was an accident. It was a mistake. It was negligent. That's why we have negligence and insurance policies to protect for that negligence. When people do create intentional wrongs, that's what the criminal courts are for. But I'm not allowed to tell a jury that insurance companies are involved. The second thing I'm not allowed to tell a jury is if the plaintiff is found to be at fault for any percentage or portion, that reduces the recovery and it may wipe it out completely. And the third thing is just that there's certain closing arguments that are just so powerful, I'm not allowed to make them anymore. And those are things that I think are unfair. But like I said, hopefully through education and people understanding, we can help even that scale a little bit more. Well, that's what I wanted to share with you today. So just a reminder again that I'm Amy Risseeuw, Peterson, Burke and Cross. We have offices in Appleton and Green Bay. We do handle personal injury cases across the state, and I've definitely done some in other states as well. If you do have specific questions about anything you're going through, don't hesitate to call me. Our number is 920-831-0300. If I'm busy in a meeting like this, my assistant, my paralegal, will go ahead and set you up with a time to chat with me. You can also find more information on our website, www.foxriverlawyers.com. Thank you everyone for your attention today. I'm going to sign off and I hope you have a good rest of the day.